picture of. Hearing will come to order. Good morning. Director Pizarchik, yesterday's hearing, the secretary committed to everyone at this table. Sorry, hold on here. Excuse me. All right, I've got to start off with my first opening statement. Good morning. Yeah. I haven't had my coffee yet. Committee will come to order. Good morning and welcome, Director. Thank you for joining us to discuss the 2017 budget request for the Office of Surface Mining. I believe fiscal year 2012 was the last time we had a budget hearing with you, so thank you for coming back. We've seen many similar budget proposals from your office since then, and you've seen many similar responses from the committee in return. Last year, however, the budget proposed the Power Plus initiative to accelerate federal funding for the reclamation of abandoned mine land areas and to promote economic development in those local economies. Chairman Rogers, Congressman Jenkins, and I took a look and supported the overall concept. Several administrative components generated concerns which prompted a retooled, streamlined approach that we thought should be tested in a few states before making changes to the underlying law. The subcommittee has a high expectation for the success of the pilot, including in the FY16 omnibus, and we'll want to discuss our vision for successful implementation today. I know that Chairman Rogers would like to be here today, but unfortunately he has some other pressing commitments at this time. We ask that his testimony be entered into the record. As you know, his district in Kentucky is experiencing an unemployment crisis. And he asked me to convey his thanks for your partnership in implementing this AML pilot project. Despite these good faith efforts and recognition by the administration of the dire straits in coal country, I share in the chairman's disappointment that the administration continues to pursue a keep-it-in-the-ground policy when it comes to coal. While innovative economic development initiatives are part of the solution, the chairman knows we will not be able to turn this situation around or provide meaningful support to the 10,000 coal miners in his district who are out of work without regulatory relief. The stream protection rule is a prime example of this overreach, and I trust you've seen the letter that that Chairman Rogers and I sent to Secretary Jewell on February 4th. Regarding the directives of the FY16 omnibus related to this rule. As we discussed with the Secretary yesterday, these directives reflect an agreement between Congress and the administration that OSM has not been working with the states as partners. We'd like to discuss how that will change this year. It's also timely that we have this hearing today, so as we may recognize the Budget Director, Ruth Stokes. Today is her last day, and it's only fitting that we offer her our gratitude for her many years of service to our country. I understand there is some room for interpretation regarding whether you're saying goodbye after 38 years versus 39 years. We'll just round it up. Just say 39 years, and I hope you have some good independent trips outside of the budget cycle ahead of you, and we wish you the best in your retirement. With that, I'd like to yield now to our ranking member from Minnesota, Ms. McCollum, if you'd like to offer any opening remarks.
Thank you. I'd like to welcome the director to the subcommittee, and I'd like to thank you for being here, and congratulations to you, Ms. Stokes, and I wish you all the best in your new phase of life, let's put it that way. I don't think women ever totally retire. The Office of Surface Mining and Reclamation and Enforcement is one of the smaller bureaus that the Department of Interior has, but it plays a vital role protecting the society and environment from the diverse effects of surface coal mining. Last year, we provided $90 million for reclamation and economic development grants will all go to 3 Appalachian states. This was a significant funding infusion, increasing the budget by 60%. These funds will support important necessary environmental restoration and economic development in some of the nation's most disadvantaged areas. These lands have been ravaged by the damaging effects of mountaintop mining. The legacy of poor environmental practices and lack of restoration has devastated communities, forcing them to contend with polluted drinking water, flooding, and the threat of leaky sludge dams. Now, I agree that the federal government should step in and help these people who have been failed by mining companies that spoil the land and abandon their responsibilities. However, I do not think the Interior bill is the appropriate place to fund this grant program. And Mr. Chairman, Minnesota has a history of mining, taconite and ore and logging. And in the 1930s, after we'd almost clear-cut from northeastern Minnesota all the way to the Canadian border and dug open-pit mines and devastated our rivers, lakes, and streams, we realized we needed to come up with another plan. Part of it was to figure out a way to mine in a sustainable way. Part of it was a way to kind of heal back the scars that we had created on the surface of Minnesota. And so the IRRB was formed, which is funded very different than how we're talking about funding today. But I say this, Mr. Chair, because I know firsthand the devastation that continues up with the loss of mining jobs up in northern Minnesota, the amount of money the state of Minnesota and the federal government has had to come in and spend in doing land reclamation, sometimes when the timber companies and mining companies walked away from it. So I offer that in the spirit of I want this to work, but I do want to be clear that I think there's another revenue stream or other ways in which we can move forward in the work that needs to be done in these Appalachian counties. And with that, I yield back.
I thank the gentlelady. Director? Oh, excuse me. Director, you're recognized for your opening statement.
Thank you, Mr. Chairman, Ranking Member McCollum, and Congressman Jenkins. I appreciate the invitation to testify here today on behalf of the administration's fiscal year 2017 budget request for the Office of Surface Mining Reclamation and Enforcement. The Surface Mining Control and Reclamation Act of 1977 established OSMR for 2 basic purposes. Our primary obligation is to ensure coal mines are operated in accordance with the law to protect citizens and the environment during mining and to restore the land and water after mining. The second basic purpose is to implement an abandoned mine land program to address the hazards and environmental damage caused from historic coal mining. SMCRA strikes a balance between protecting people and the environment while enough coal is mined to meet our energy needs, but prohibits the issuance of permits to mine coal where the land and water cannot be restored. Nearly 39 years have passed since SMCRA came into play, and coal remains an important fuel. It is used to generate about 34% of our electricity. OSMR is committed to proper implementation of SMCRA together with the states and tribes. SMCRA has been a success at improving land reclamation, but when it comes to protecting our water and streams, we have significant opportunities to do better. We know more today than was known 40 years ago, and we continue to strive to completely implement the law to protect the people and the environment. The states, tribes, and OSMR have been successful restoring abandoned mine lands. For example, over 380,000 acres of dangerous abandoned coal mines have been reclaimed. Now, to put that in perspective, if all of those abandoned mine lands were in one place, it would cover an area about 10 times larger than Washington, D.C. Similarly, there were 3,443,188 feet of dangerous high walls, basically man-made cliffs that were created by coal mining and abandoned, that have been eliminated. If all of those high walls were lined up end-to-end, they would stretch clear from Washington, D.C. to Detroit, Michigan. We can take great pride in what has been accomplished, but it will take several $billion more to complete the job reclaiming the abandoned coal mines. Please remember, every community that has polluted waters or rivers or dangerous pits has been waiting at least 40 years to have their environment restored. In FY 2016, we gave the states and tribes $224.6 million of abandoned mine reclamation funds, but we were required to withhold more than $1.3 million of their money because of sequester. The people of coal country should not be shortchanged by sequester when we have their money. In this case, the Budget Control Act imposes impacts on some of our most needy people, and it does so in a way that actually, in my opinion, counteracts the goals of the Budget Control Act. I urge you to end this penalty on coal communities, because since that law came into effect, we have been forced to withhold almost $71 million of money that we collected from the industry to provide to the coal country, and there's, in my mind, no good reason why we should continue to do so. We ought to get that money on the ground to where it can be used. Standing in stark contrast to sequester is the $90 million, Mr. Chairman, you referenced regarding the AML economic development funds that were provided in the omnibus bill. I commend Chairman Rogers and Congress for their efforts to help coal country communities. I commend each of you who voted for this appropriation. Your actions in this regard truly give meaning to the phrase of government of the people, by the people, for the people. Working together, we can pass a budget that supports responsible coal mining and reclamation and which protects coal miners and their families who have been abandoned by the mining companies. The 2017 budget request totals $157.9 million in discretionary spending, a decrease of $82.6 million from the 26 enacted, and that is because of the one-time $90 million pilot project that you referenced that we're moving forward with it. But we believe our 2017 proposal more than offsets that with the $1 billion legislative proposal to promote reclamation of abandoned mine lands to accelerate the disbursement of that money out of the AML fund. We have the money, and I again commend Chairman Rogers and everyone who has joined him in sponsoring the Reclaim Act. I think that is a very good step in the direction to help these communities that need the assistance. And more importantly, we have their money. The discretionary budget provides full funding for the states and tribal regulatory grants. It enables OSMR to address existing legal obligations and demands, such as technical assistance to the states and tribes to help them do their jobs, increased NEPA workload requirements for environmental assessments and environmental impact statements for mine plans, in that area of evolving law, and to process state program amendments. It also invests in technology for the future. It proposes to expand the coal mine geographic information system and to enhance digitization of underground mine maps in order to protect miners and the public from the dangers of the abandoned underground coal mines. And we propose to expand reforestation of our former mined lands to create job opportunities for our youth. We know that we have well in excess of 1 million acres of ground across the country that has been formerly forested but is basically grassland since mining and reclamation. On the abandoned mine area, we propose mandatory grants, a request of $914.4 million in permanent appropriations. Of that is the $200 million a year that we propose to accelerate from the disbursement of the AML fund, including other money for a total of $374 million. And we propose additional funding to the United Mine Workers of America Health and Benefit Trust Funds and for the 1974 pension plans for a total of $540.1 million. That includes the $375.4 million of the new proposal. That will provide health care for people who are losing their health care because of various bankruptcies in the coal industry, and it would provide funding to us to provide to the Pension Benefit Guaranty Trust Corporation to provide to the 1974 pension plan, which is on the verge of insolvency, and where the median retirement benefit is $270 a month. This proposal, the legislative proposals to revitalize our communities for accelerating that disposal, again, I look forward to working with Chairman Rogers and every member of Congress to accelerate the disbursement of that money out of the fund. There are also 3 other proposed changes to the current law. One would eliminate the payments to certified states and tribes. Those are states and tribes that have certified they have completed the reclamation of all of their abandoned coal mines. That is projected to save about $520 million over the next 10 years. There's a legislative proposal to restore the reclamation fee to the original levels from 1979, and that would generate about $49 million additional dollars in 2017 that would immediately go to the states in 2018 to reclaim high-priority abandoned coal mine sites. And there is a proposal to establish a hard rock AML program with a fee so that that industry's problems that were created prior to the regulation of mining can be addressed, much as the coal industry is playing to clean up the legacy that it had created. Finally, on February 4th, Chairman Rogers, Chairman Calvert, and others sent a letter to the Secretary raising some questions. And in regards to those questions, number one was, what is OSMR's plan and schedule for providing the information to the states? We have been collecting the reference documents from the proposed rule, and beginning on Monday, we started to upload those to federalregs.gov to make them available to the states who have requested, and anybody else for that matter who would like to see it, to make it easier for them to see. And earlier this week, we sent a letter to 16 different states providing them those details. We are not uploading the copyrighted material because by law, if we were to make that available or copy it and make it available, we would be violating the copyright law. But what we have provided is explanations and guidance to the states on how they can access those copyrighted materials, as well as working with them to provide those copyrighted materials if, in the way we can. We've offered the services of our librarian in that regard. On the second question, it was what is the manner we plan to accommodate state requests for meeting. As I indicated, to date we've had, I think, 16 requests from the states to meet. What in my response to the states that went out earlier this week, what we have proposed to do is at the upcoming Interstate Mining Compact Commission in mid-April was to use the time that is on their schedule for the state's OSMRE meeting to meet with them. We believe it is the most efficient way for everybody to get together. It will allow all the states who are planning on being there to have the benefit of having that meeting with us without any additional cost or expense. And the third question was, how will the results of the meeting be incorporated into the administrative record? Our plan is to prepare a summary or summaries of that and have that included in the administrative record that we are producing for that role. With that, Mr. Chairman, the last point is I thank you again for the opportunity to be here today. My full statement has been provided for the record, and at this point, I'm available for questions.
Thank you for your testimony. Yesterday, we had the secretary out, as you know, and she committed at this table that the department would fully comply with the stream buffer directives in the FY16 Omnibus Appropriations Bill. There were multiple opportunities for the Secretary to inform Chairman Rogers and this committee that you sent letters to the states this week outlining what information is publicly available and where the states may find it if they look in the right places. Unfortunately, we were not told until after the hearing, and it's not clear as to whether that decision was strategic or circumstantial. Regardless, it casts a cloud on what would have been a good faith effort to begin to repair a 5-year dysfunctional relationship with the states and finally work with them as partners. Instead, it appears to be business as usual for those who have been working on this issue day in and day out. Further, as my good friend Ms. McCollum can attest, there are times when the laws enacted by Congress may require some clarification, especially when there's give and take on both sides to reach an agreement. That happens, and we are always happy to provide clarification to the offices under our jurisdiction. So we're all on the same page. To quickly review how fiscal year 2016 transpired, the committee directive to OSM started as a directive to stand down on the stream buffer rule because OSM failed to work with the states as cooperating agencies. For years, OSM had broken its word to the states. Where Chairman Rogers and I come from, you are only as good as your word. And that means something. We're kind of old school in that regard. OSM had broken the trust of its state partners, and states with both Democratic and Republican leadership withdrew from the process as their voices were repeatedly ignored. The common denominator was OSM. In order to put a final appropriations package together for fiscal year 2016, the Congress, the White House, the Senate, and the committee as a whole had to agree on how to resolve this issue. While there may have been some disagreement on the initial approach, the committee as a whole agreed that OSM needed to re-engage with the states as partners in this process. So, Director, in order to avoid any confusion, any ambiguity, or any alternate interpretation of the committee's direction or intent, Chairman Rogers and I and my fellow committee members fully expect you to work with the states as cooperating agencies as you have collectively agreed in 2010. The source documents you have, they will now have. Not web links and not an address of a library where they may obtain the information. The analysis you have, they will have. The conclusions you reach, they need to agree with. Equally, the conclusions they reach, you need to agree with. Otherwise, there isn't going to be a rule. For 5 years, OSM's work on this rulemaking has been proven to be a one-way street. That's over. The Congress and the administration have agreed that you collectively need to work together. I trust that your letters to the states this week serve as the first step in the process of information sharing, and April 18th will be the first of many meetings with the states in order to foster a substantial dialogue and exchange of ideas. But I need to verify that. Can you please do so for the committee? Can you please verify for us that the letters this week are the first step to re-engage in a meaningful partnership with the states, including the first exchange of data and the first of many meetings? I don't want our first exchange at this table to be one where I find you in violation of a directive of this committee.
Thank you, Mr. Chairman. We have provided documents and made it available beginning last summer when we published the proposed rule. In October, we have also extended an invitation for the states to re-engage on the preparation of the EIS. And we've had at least 15 meetings with various states on comments that they have provided during the comment to get more clarification on that. Assistant Secretary Schneider has visited Alaska and is planning on visiting North Dakota as well. And so the letter that I sent out yesterday is another step in our process to re-engage the states. The states were involved in the beginning of the process. They provided many substantive comments. Their comments were very helpful in fashioning the final EIS, and we again extended the offer to meet with them. We did it in October. We did it again yesterday. We will continue to attempt to engage with the states and to work with them to get their input.
And they want to work with you. They've made it very clear that they want a meaningful partnership. And so are you committing that you're going to work with the states and have a number of meetings and exchange information with them?
We've already extended that invitation back in October. And again, the one I sent out yesterday is to the 16 states have requested, but we're willing to meet with any of those states because of that special relationship that we have between my agency and the states as the primary regulators. So we will meet with them. If they want to meet before then, fine, but we are attempting to get their input and to re-engage them in it. Right now, I've made the offer, and yesterday I spoke with Greg Conrad, the Executive Director of the Interstate Mining Compact Commission, and he indicated to me that he would be talking with his members to see what their response would be. So we've made the offer. We made the offer in October. We made the offer again, and it's going to have. They'll have to accept for us to have a meaningful exchange. I can only keep offering, but I can't have a meaningful exchange if they choose not to meet with me.
Well, I'm sure we'll be hearing from the states to determine what they think. Ms. McCollum?
Not at this time, Mr. Chair.
Mr. Jenkins?
Thank you. The chair. Thank you, Mr. Chairman. Director, thanks for being here. The question came up yesterday that the Secretary was asked how much money had been spent on the stream protection rule. I assume over the last 24 hours you all have had a chance to nail down that number, and hopefully you're prepared to tell us how much has been spent on the stream protection rule over these last 5, 6, 7 years.
Thank you, Congressman Jenkins. Yes, we have been tracking that. There's been interest in it. And we have spent approximately $6.5 million for contract support on preparing the rule with the draft environmental impact statement and the regulatory impact analysis. And then we also have spent a bit over $4 million for our staff time on working on the documents and putting together, attending public hearings, responding to comments, meeting with the states, et cetera.
So total amount spent for its entirety from its initiation many years ago, OSM has spent $10.5 million.
Actually, I think it's about 10.6.
Okay. Back to the issue that the chairman raised, and I want to point out the operative words in the language that, again, the secretary yesterday said would fully comply with. And those are, as the chair said, these are the words: re-engage, meaningful manner, before finalization. Re-engage, meaningful, and before finalization. I really want there to be emphasis on each of those as we move forward. So, the states received this March 1st letter from your office, and I've listened to your testimony carefully, and I've listened to your answers to the chairman's, and I think clearly, I think you are not satisfying certainly the first two, and hopefully not the third piece of this. Number one, the idea that you would send a letter and then simply include what I understand is over 100 pages of basically bibliography and putting it in the laps of the states to say, here's a conference, or here's a document, or here's a book, or here's a study. If you want to go out and check it out, fine. What we said is OSM is directed to provide the states with all technical reports, et cetera. So my question to you is, do you believe, based on this letter, based on what's already been uploaded, and based on what you say will continue to be uploaded, do you think you have complied with the directives of providing all of the reports? Is this all you're going to do, is post things, or are you going to be packaging up the things, what we've asked for, and actually sending it to the states?
Congressman Jenkins, we had a number of requests that came in from the states, and I believe, if I remember correctly, a number of them asked for us to provide a list first, and then they would decide which ones they wanted copies of. We've gone beyond that by uploading things to the gov.regs site, so they have access to it. We had heard some concerns that perhaps some of the websites or links that were referenced in the published documents were not working. We have taken steps to make sure they have access to available to all of those. I'm not sure that the states would have appreciated having huge volumes of written materials submitted to them. We're giving them the opportunity, pursuant to their request, to look at what it is they want to do, and we're working with them to try to give them access in a reasonable manner so that they have the opportunity to look at
Well,
these.
then I will be satisfied. What you are describing is that you are allowing the states to decide how best they would like to see it. And I think I just heard you say, so if West Virginia, for example, my state, requested all of the material pursuant to this in writing, in document forms, you would provide that.
We have it already provided up on the website or on the plate where every document that is not subject to copyright is available for them. They have, it's easy, it's an efficient way
If
to
the
do
gentleman
it.
would yield on that point, when you say something that's not subject to copyright, if the United States government enters into an agreement with a contractor to provide a technical report, who is it owned by? The author of that report or by the United States who paid for that report?
I believe if you're talking about the report itself that was prepared by the contractor, I think that would be owned by the government. The copyright material.
I just want to clarify that. Then a report that it's done on behalf of the United States government is owned by the government, and I don't believe that would be subject to any copyright rule.
I'm not a copyright expert on that. I'll defer to your judgment on that, but my understanding is that's not what we're talking about. Some of the report that we prepared references a variety of studies and reports. Some of those documents are subject to copyright.
If those reports are being used to create a conclusion in order for you, which we're talking about, then those reports should be made public and be part of the information to provide it to the states.
Mr. Chairman, all I can say is it's, in discussing this with our lawyers, my understanding is if we were to take copyrighted material and make copies of it and distribute it to folks, that we would be violating copyright laws. And I don't
find
think
it-
anybody wants us to do that. I know I certainly don't want to be doing that.
Mr. Chair, maybe we should ask CRS that has a copyright division to get back to this committee on that. Would that be helpful to all of
Yeah,
us?
I'd like to find that out specifically.
Let's
The
direct
information
the
that
committee staff
potentially
to find that out then for us.
is being withheld, we
Thank you,
need to
Mr.
know
Chair.
that. Yeah, thank you.
In your testimony, you said one of the reasons you were pursuing this course is you didn't think the states, quote, would appreciate just sending a lot of material. What that tells me is that you would be willing, if they did appreciate you sending the materials, that you would do so. So don't suggest you thought that they would appreciate and then turn around and say, but even if they do want it, we're not going to do it. My next question is the issue of meeting. Part of the fundamental operation of this law is the fact that each state is unique. When you go back 30 years and look at why this was formed in the first place, and I hear you talking about a process, and I want to try to be very clear. With regard to your offer of having a group meeting, once the states have had a chance over these next weeks and months to view 100 pages of bibliography in whatever form they can ultimately get the documents in, each state is going to want to sit with you and have a discussion and to talk about the implications for their state. Can you reassure me that it is not the position of OSM that the meeting on this particular date that you've suggested in April satisfies the meeting request requirement of the law? And then if my state in West Virginia wants to re-engage, which they have already sent you a letter that they do, and wants to meet after looking at this in April or May or June, that you will afford them the individual opportunity and that you will not just check the box for the meeting requirement at the April meeting.
Thank you for that question. We received your state's request, I believe, yesterday and responded to it. And at this point, we have the invitation out to the states to meet. We're waiting for them to respond. I'm still waiting for the states, like your state and other states, to respond to the invitation I sent in October to re-engage. None of them have responded to that. And at this point, we're making our effort to do that. And I apologize for making an assumption on what maybe the states were thinking. We have made all the documents, or are making all the documents available that are not subject to copyright, so they have access to those, and they have the opportunity to look at those documents themselves and evaluate which ones
Let's
they
go
want
back to the
view.
meeting. I hear that we've addressed the document. If after a thorough examination of these documents, our state wants to sit down with OSM at an appropriate time, one-on-one, re-engage with our state, whether that be in April or May or June, to have a substantive discussion, are you willing to do that? And I just want to make sure that you do not think that you can check the meeting requirement box based on this April meeting.
Mr. Congressman, in regards to meeting with folks from your state, we had the invitation back in October. We met with them. My deputy director and assistant secretary met with them. I believe it was
But we didn't have these documents. We don't have all the things that you are loading. Understand, this needs to be a process. We put that in the requirement of the law. You are now having to upload it. You, even by your own admission, they're not all up yet. You got 100 pages of references. Give us a time, if you're really sincere about re-engaging and working, give us time to work through the documents, analyze, study it, and then sit down with you and talk about the implications to our state. Will you do that?
Congressman, many of those documents have been available to the states since
But
July.
not all. Have all of them?
Not
All of them?
And they
Then
will
give
be,
us time. Give
and-
us time.
And we are doing that. We have, they're being uploaded. They might even already be done today. I haven't checked this morning with the staff on that, but those ones that are
Clearly,
being
to me,
uploaded.
you will not, and I've got one more question, Mr. Chair. Clearly, you can't bring yourself to say, we're going to give you a chance to look at all the documents, and we're going to give you a chance to sit down with us individually and talk about it. You keep talking about what's already up, or we're still putting stuff up. So I'll follow up with you, but my clear belief and feeling is the requirement in the law that Secretary Jewell says you will comply with will allow, re-engage, provide the material, meet with the states before finalization. My last question, real quick, is I was very concerned during your testimony when I heard just a moment ago that you would provide a summary of the engagement from the states or any feedback. What I would like, and I'm hoping, is that the product where states do work with you in whatever form or fashion, in whatever context, that the individual states' comments are submitted for the administrative rulemaking record, and that you give substantive response just like a normal comment period. Can you assure me that all the states' input, each and every state, not in summary form, and I'm reacting to your word where you talked about, you said prepare summaries and put it in the administrative record. That, in my opinion, clearly does not meet with our expectations. Will you assure us that it will not be just simply summaries, that you will allow for specific input of the comments and then the feedback from each and every state into the administrative record?
Congressman Jenkins, as I understand your request, basically you're asking us to reopen the comment period. And unfortunately, no, we're not going to reopen the comment period. The comment period was open back last summer. We extended it. We had the documents available for the states. Beginning earlier this year, we got some of the requests in, so we're making all of those documents available. And the links may not have worked on that. We will meet with the states. We will obtain their input. But we are not going to reopen the comment period, and we're going to get this rule done.
Well, thank you, Mr. When will the rule be done?
Our hope is to have it done this summer.
Do you know what the date is?
I do not. I've learned many times in this process that it's not possible for me to predict when a rule will be proposed or finalized on that. There are too many steps in the process outside of my control.
Thank you, Mr. Chairman.
Mr. Joyce?
Thank you, Mr. Chairman. Director Pizarchik, certainly you recognize that the imposition of the proposed stream protection rule has a lot of potential impact and regulatory costs that has forced thousands of miners in Ohio to lose their job and companies to go bankrupt. What are your plans to cope with the significant reclamation liability that's going to be there due to the result of these excessive mine defaults?
Mr. Congressman, I would have to disagree with your assessment. The stream protection rule is only proposed. It has not caused any bankruptcies. It has not caused any job losses. It's not in effect yet. We're still working on consideration of the comments that we received on the proposed rule, and we will be making changes as appropriate in response to the comments that have come in on that.
None of these companies are going to come back into existence.
I believe that if they're going out of business and going out, there are other forces that are at play. There are market forces. Cheap shale gas, cheap, plentiful shale gas is taking market share away from coal. You have the economic downturn around the world. You've got the Chinese economy slowing down. The exports are dropping on that. They've been overproducing coal. This rule has not had any impacts on the industry. This rule isn't even final yet. So from the standpoint of any impacts or job losses on that, that's not here. And then with the analysis that we have completed, that was peer-reviewed by outside experts, our calculations is that what was proposed at most would be about a wash. It would be about 270-some jobs that would be lost over a 21-year period, with about 250 or 60 new jobs created over that same 21-year period. This rule does not have and will not have significant adverse impacts on employment.
That's interesting. Can I, gentlemen, yield for a second? Are you saying that this regulation, as you interpret it, has no impact on employment in coal country? Just for the record, we'd like to have that.
What I have said is that based on the assessments that have been performed,
You agree with those assessments?
we hired outside experts to perform that analysis because we believe that it would be more credible with the public and everybody else if those assessments were not performed. They were performed by outside experts.
You agree with those assessments?
Those assessments are in the draft regulatory impact analysis, et cetera. And from the standpoint that was proposed, and the whole purpose of the rulemaking and the proposed process is to get comments on it, that will be factored into it. We will see what changes are appropriate to be made based on
I would
public
take that
input.
you agree with those assessments. And obviously,
I do not disavow them.
the industry, when they anticipate a regulatory cost, they must be wrong about that, because based upon your assessment, there is no cost. Mr. Joyce, go ahead.
Well, how will the primacy state regulatory agencies be able to cope with the added responsibilities and authorities being proposed in the stream protection rule? It seems obvious that the costs in time and money to the states and the miners will be increased as a result. How would this not be the case?
The way the states can adjust to that is they have an option under the rules. They can either gather the baseline data to determine what types of resources are in the streams out there prior to mining, do the monitoring, et cetera, and then ensure that the streams are restored after the mining. Mining company has the option to choose whether they want to mine through the stream, or the states can give literal interpretation to their existing rules and not allow the streams to be eliminated through mining or being buried. And if they do that, that is a less effort on their part. They won't have to gather as much baseline data. They won't have to get into some of the other new standards that are designed to protect streams. And let's face it, the law has always had a provision in it that prohibits permits from being issued where it is not possible to restore the land to its original conditions and productivity. And land without water or land with polluted water does not meet those requirements. What we are proposing is to gather the appropriate information so that We know what's in these streams before mining, the water quality, the critters that are living in it, and so we can measure whether the mining is successful or not. And in some areas, I'm sure that mining will be able to restore it. In other areas, I'm sure that they cannot get a permit and should never have gotten a permit to do that mining because it does not comply with the federal legal requirements.
So that's why you feel it's necessary to be involved in stream biology?
The stream biology is a good indicator of what's happening in the stream. If the critters can live in the stream prior to mining, during mining, and after the mining, then we've been successful in the mining and reclamation. If the critters living in the stream are there before mining, but during mining they get wiped out, and after mining they're wiped out, then obviously there was a failure to comply with the regulatory and the statutory legal requirements governing coal mining reclamation.
I've exceeded my time, I know. Mr. Chairman, thank you.
Ms. McCollum?
Thank you, Mr. Chairman. So, I've been part of this discussion for a while now, and there's a lot of tension and conflict surrounding the stream protection rule. But the basic part of this rule is to protect water resources. And as we sit around the table, we don't place a value on water until it's gone or we can't drink it. Flint, the drought in California, some of the other places that have happened around the country, then all of a sudden water has a value. Water has a value then because it is, whether it's for agriculture, sustaining us through food, or whether it's sustaining us through drinking water, then we start talking about water as a right. And I believe access to clean drinking water is a human right. And therefore, we have a responsibility to make sure that we work with industry, that we work with states, that we work with local units of government to protect the ability for all of us in this country to have the right to have clean drinking water, the right to have water available to do agriculture, the right to have water available for recreation or for fishing, or sometimes the fishing industry. So I believe that that's at the heart of this rule. And I know that there's tension on how we get there. But if we don't assess that water does have a value to begin with, it's very easy to discount this gift that has been given us that's life-sustaining. And I know all of us around the table want to get to the point where we find that balance, and it's hard to find it sometimes, but we find that balance where industry can move forward, agriculture can move forward, recreation can move forward, but the bottom line is future generations will judge us on how we protected this basic life source of water. And so the tension's natural, but we have to remember when we start this equation, we don't have a dollar value on water when we talk about it. It's only when it's gone or it's polluted that we can't use it that all of a sudden we say, oh, what happened to the water? So could you maybe tell me a little bit more about the goals and the objectives just for public health? Forget the recreation now, just for public health that you're trying to accomplish.
One of the primary purposes of the rule and the standards is to establish what kind of water is out there to begin with. And our law has always prohibited causing material damage to the hydrologic balance outside the permit area. That's a mouthful. But we've never defined that. We are proposing to define that based on the existing conditions that are out there and to gather the baseline data to prevent those water resources from being polluted, to protect people's health. We know that in some areas selenium can be mobilized by mining. It bioaccumulates. It causes reproductive problems in the aquatic community, and it can cause health problems at too high levels in people. And if people are drinking that water or eating those fish that have high levels of selenium, it can have adverse impacts. There are also any number of studies that purport to show that there are adverse health effects near where there is extensive coal mining going on. We need to get answers to these questions in order to make sure that the people there are not being accidentally poisoned or to assure people that there is no danger. Whichever the case is, we have to get to the bottom of that. But protecting the water, taking the measures and requiring identification of what's there, and to prevent the mining from causing pollution that causes those kind of water problems is the first step. And we feel that if you protect the most sensitive critters that are living in those streams, that you're going to be protecting the water so that the people who live in those communities are protected as well.
Thank you, Mr. Chair. Mr. Shores, we found out with taconite tailings in our state from mining, it caused cancer, and we had to go through a very extensive research. So I'm actually glad we're being a little proactive. We have to find the balance, Mr. Jenkins, but we have to be proactive because some of these things that are lurking out there are potential carcinogens. Thank you.
Thank you. Quick comment. I'm going to recognize Mr. Jenkins. So I used to chair the Environment Committee on Science, and one thing we need to make sure of, no matter what your position may be in some of the various issues that we have before us, that the science is untainted. Because I have seen a lot of science that, on both sides that have a political ramification to it. So science is science. It should be unbiased and not for a particular purpose. Mr. Jenkins.
Thank you, Mr. Chairman. I just want to summarize real briefly. I think this hearing and having you here is really a real opportunity to let us air out and have an open discussion about expectations. And I just want to, for the record, make it very clear that I think a website, a 2-page letter with 100 pages of bibliography, a meeting in April, and then a summary in the record is not meaningful, in my opinion. So I'll look forward to working with the chair of this subcommittee and the full committee to try to re-engage OSM so we can maybe find out what truly would be a meaningful process to satisfy what everybody agrees is mandatory. So I think we have cleared up here that, in my opinion, what you are proposing does not satisfy the meaningful requirement. So we look forward to working with you to try to work towards a compromise of what would be meaningful. Secondly, relating to the AML, the $90 million projects, and again, the opportunity to work with you, one of the questions that have risen is, are those AML projects, or the projects that money will be able to be used for with a nexus, are they restricted to just those is it 1967 sites, or can it be sites post that? So the $30 million for West Virginia, are the properties that a project that has a nexus to abandoned mine, can the funding be used even if it was an abandoned mine from 5 years ago, not 50 years ago?
Congressman Jenkins, that's a very good point to make. The Surface Mining Act drew the line at August 3rd, 1977, when it became
77.
effective. Yes. And so,
are you applying that 77 line for this special $90 million project? I'm hoping you don't.
I'm going to follow the law and the way the Surface Mining Act is written. There are two distinct categories. There's Title V, which deals with active mining. That's all mining that has occurred since August 3rd, 1977. And AML money, this $90 million, cannot be used on those types of sites. The law only allows us to use it for sites that were mined and abandoned prior to August 3rd, 1977. So that's where the nexus is, and that's the standard. You know, we have to carry out the law, and that's how it's provided.
And then finally, on this issue, have you, from the follow-up discussion with Chairman Rogers and myself, have you all come up with ways in which to expedite and facilitate getting projects approved, getting this money out there?
We are working on that, and as one of the follow-up, we are drafting a guidance to help with that, and we are putting together some meetings with the state AML folks, with EDA and ARC and the state economic development folks, and to get everybody together to help identify those projects so they can move forward more quickly. The process that we use for funding the grants is the expedited grant process, and we continue to do that. We will do it in a manner that will allow those projects to go as quickly forward as possible in light of the various other legal requirements that come into play. But yes.
Gentlemen, would yield for a
Yes.
moment. The pilot made no distinction on the pre-1977 sites or sites after 1977. So I want to make that clear. So we want to make sure that there's a difference between the pilot program that's passed in law versus the AML.
Mr. Chairman, we will go back and I'll ask the lawyers to take a look at it, but my understanding from the previous analysis that was performed and where the addition was made is that it
But
put
certainly,
it
if you
into Title
want,
IV.
the intent of this committee, the committee's intent is that the pilot program language is what is in law.
Thank you for sharing that. And on your, if I may, on your comment about the science, about needing to have a good basis, Secretary Huffman from West Virginia several months ago had asked for help on assessing some of the science that's out there as whether or not health problems are being caused by coal mining in West Virginia. And we have reached out to the National Academy of Sciences, and we are working with them to try to bring them on board to bring in the appropriate experts to look at the science that has been done and evaluate that for the purposes of making a determination, is that good science or not?
Mr. Jenkins.
Mr. Chairman, thank you for bringing that, and I appreciate your sensitivity. I know you've been fully engaged. I share your feelings. We have sat with OSM directly to raise our concerns that they are imposing criteria, standards, requirements for this pilot project that's under the traditional AML. I know that was not the intent. It was not the letter of the law. We're trying to politely encourage, poke, and prod them to not treat it in the traditional way, but in the manner in which we intended, and we're trying to make progress. But thank you for that comment. This was not intended to be restricted to pre-1977. And my last comment, Mr. Chairman, you raised your attention, obviously, on the jobs issue. Just simply, this is why this whole issue is so important relating to the stream protection rule, stream buffer zone. By their own analysis, or by their supposed independent analysis, they think that there will be 260 lost jobs nationally, 260. And that there would be 250 jobs created by compliance, and that the entire net impact is 10 jobs. We have independent studies that suggest that the impact just in Appalachia will be 50 and 60,000 jobs. So when you're talking about a net 10 jobs nationally versus just in my neck of the woods, 40 and 50,000 jobs, there is a gulf of disagreement in why the true re-engagement, getting these documents that they haven't been willing to share before despite repeated FOIAs, we've got to get to the bottom of this. And this idea that we're rushing to the September of 2016 after 6-7 years of effort, we know why they're rushing, it's obvious. But we put in the law, and the Secretary says it is a requirement. It needs to re-engage, it needs to be meaningful before you finalize. So once again, do not finalize until you satisfy what the Secretary says is a requirement, that you must re-engage in a meaningful manner. And I've said it clearly from my perspective here, what you are outlining, which you have clearly stated, is, in my opinion, is not meaningful.
Thank the gentleman. Any additional questions, Ms. McCollum?
Well, not a question, just a comment. I understand the discussion about the pilot program, and I get the difference between 1977 and legacy mining. But I, for the record, want to reiterate again that this $90 million coming out of the Interior budget with other things going on is concerning to me, because we have so many unmet needs. And I would point out that Minnesota figured out quickly that the taconite companies had to be part and parcel future moving forward and being part of the reclamation and other things like that. So I agree Appalachia is feeling a lot of pain right now. And I agree that I want to see this issue be resolved. But I also want to be very clear that, funding and monies coming forward to do this literally can't be at the expense of other communities or other mining communities that have figured out other ways to kind of reclaim some of this money. So I look forward to working with you, Mr.
Thank you.
Jenkins.
Can I, very politely, would you yield for one moment?
Yes.
Thank you very much, Mr. Chairman. The distinction is, in my opinion, this money, and you're very appropriate if we were taking money from AML that would be potentially used for other projects. The $19 million is not coming from AML. While it is going through Interior, this came from the Treasury. So this is not AML money. It's not taking from Peter for Paul. So that's our issue, is it's the source of this money. While the mechanism comes through his office, it's not traditional AML money.
And I understand that, Mr. Jenkins, but as things change and as budget discussions happen, I just want to lay a marker that it not come out of Interior. Thank you very much, and thank you, Mr. Chairman.
I thank everybody. I apologize. I know that this is a very important subject, but we have a BLM hearing that's starting right after this, and so I must adjourn this hearing. Thank you for your attendance. Appreciate it.
Thank you, Mr. Chairman, members.